No, she promised that would work. There. I have to put a disclaimer in all my written materials so that you know that this is not really legal advice, and that if you have any questions, you need to talk to your respective county attorney or whatever. But this is kind of an overview of the law.
Which county would you recommend?
Well, let's see. Actually, Monroe County has a really good county attorney. Madison, yeah, she does. Now, Madison County, I don't know if I know your county attorney.
We have a law firm. It's Wilson Fair.
Okay.
They're good.
They're good too. So, and I've worked with several different attorneys from Brown County over the years who've represented the county. So, I don't know of a bad county attorney. So, just, you know, and if you can't get your county attorney to talk to you, call somebody at the AIC and they'll find someone to get you the answer. Okay, the topics we're generally going to cover are sort of generically known as the public access laws. It's the Access to Public Records Act and the Open Door Law, or in shorthand, the Public Access Counselor refers to the Open Door Law as the ODL and refers to the Public Records Act as the APRA. But I probably won't. But if you see opinions of theirs, of his, that's what it is. Okay, things we're not going to talk about today because these will take up a whole workshop in and of themselves. Things that deal with public records that are statutes outside Title V. And are there any recorders here? Yeah, you have beaucoup statutes outside Title V. So we're not going to talk about your statutes, okay? Yeah. We're also not going to talk about that. And again, this is the statutes for imposing fees for filing or recording verbal copies. Again, that's pretty unique to recorders, so we won't be talking about that. We're not going to talk about access to adoption records or access to court records, so I'm sorry, Nicole, if that's part of your job, but we're not going to do that. We're not going to talk about the statutes requiring publication in a newspaper of notices, because that's another statute. We're not going to talk about law enforcement records, because again, that could take an hour in and of itself, or healthcare records. And I'm not going to say that's because HIPAA doesn't let me talk about them, but you know, healthcare records is also a day-long topic. So, when the public access laws were first enacted in the late 70s and early 1980s, the General Assembly said pretty much that the public purpose of these public access laws was that government should be open and accessible to the public, and that they should be liberally construed. And when in doubt, access is always the preferred answer. So whether it's a meeting or a record, if there's a question about whether a meeting should be open or a record should be disclosed, generally speaking, you err on the side of disclosure and access. Okay, we'll start with public records because I think this may be more applicable to most of the folks here. Public record is, and the statute has a fairly broad definition. It's, well, I guess we'll start with copy. To copy means to transcribe by handwriting, to photocopy, to Xerox, to duplicate, to put on electronic media of any kind. To inspect includes the right to look at a document, to manually transcribe it and make notes or memoranda. If it's a document or record that's stored electronically, it includes the right to duplicate the data onto any other medium of electronic storage. And then public record, this is the key, is any writing, paper, book, study, report, map, you name it, of any kind that is I love this, created, received, maintained, retained, generated, or filed by a public agency on whatever medium. So it could be paper, could be a rock, could be electronic media, whatever. Generally speaking, every record is a public record. But not every record has to be disclosed. The Public Records Act, or the APRA, recognizes 3 distinct categories of public records. There are confidential records. There are what we call discretionary records, and then there are disclosable records. Okay, confidential records. According to the statute, these are records that may not be disclosed by the public agency unless you're required to by another state or federal statute, or a court orders you to during the course of litigation. So these are things that cannot be disclosed. Among those records are obviously those that are declared confidential by state statute, those that are declared confidential by a rule adopted by a public agency that has specific authority to classify a document as confidential, those required to be kept confidential under federal law, and that's where HIPAA and all the health confidentiality comes in. Records containing trade secrets, records containing confidential financial information obtained upon request from a person, records that are declared confidential under the rules of the Indiana Supreme Court, and the recorders know this particularly, but Social Security numbers are confidential public records, and those have to be redacted. If they're present in a document, they have to be redacted. Okay, that's pretty much the universe of things that may not be disclosed. So if somebody comes in asking for one of those kinds of records, your response, generally speaking, is, I'm sorry, those records are not disclosable. Okay, the second group, these are discretionary records. These are records that, in the discretion of the public agency, may or may not be disclosed. It's up to the public agency. So personnel files, it's up to you to disclose or not disclose, except certain kind of basic identifying information, which is like, well, this is almost everything. You have to disclose their name, compensation, job title, the business address, their education and training background. By the time you've figured out what you have to disclose from what you don't have to disclose, there's not much left that you don't disclose, at least with regard to personnel records. Records, this is the big category that most public agencies use. Records that are intra-agency, so within your agency, or inter-agency, so between agencies, advisory or deliberative material, including material that's developed by a contractor like myself, or in the case of, say, the clerk's office, so we use the assessor's office. The entity that the contractor you may have hired to help with assessments. In the case of the clerk's office, it might be somebody that you've got helping do data entry or help convert judicial records into electronic media or something like that. Under contract with a public agency that are, generally speaking, supposed to be expressions of opinion or are speculative in nature and that are communicated for the purpose of decision making. So let's say, like in the case of the commissioners trying to decide whether or not they want to build a new jail in the western half of the county or the eastern half of the county, the information prepared by the architects and engineers and surveyors about the pros and cons of each site. It is speculative. It's to help them to reach a decision. So that is something that the commissioners could say, we don't want to reveal that. Or they could say, you know what, we're going to let the public see everything. It's up to them. Records relating to negotiations between, and the statute has a whole laundry list of things, but pretty generally speaking, say between the county and an economic development prospect, say, an example of, we'll use Decatur County when Honda was coming to town. All of the records, the exchanges back and forth between the county and the county's consultants and Honda and its consultants did not have to be revealed or disclosed unless the county wanted to until the end of negotiations. And once the final offer had been arrived at and reached in the terms of the incentives, then that final offer has to be made available. Another category, we've had this for a while, but it got kind of expanded this year in legislation. The investigatory records of law enforcement agencies, generally speaking, are discretionary. There are a few things that have to be disclosed, but generally speaking, those are don't have to be disclosed. But law enforcement agencies are now able to share certain investigatory records, or all of them, with a victim's advocate or a victim service provider. They can share with them, but that doesn't mean that they have to share them, say, with somebody else, say the newspaper wanting to write a story about it. Okay, if your record doesn't fall into one of the first two things I talked about, it must be disclosed. So that's like almost everything else. You may have to redact pieces, but generally speaking, it's going to have to be disclosed. So anybody can come and inspect and copy the public records of a public agency during the public agency's regular business hours. A request to inspect or copy must identify with reasonable particularity, that's the phrase the statute uses, the record being requested, and in the discretion of the public agency, that request can be made in writing. And this is something I encourage all public agencies to do, is to adopt a policy that says public records requests will be made in writing. And there are a couple reasons for that. One is that it helps maybe eliminate some misunderstandings if the person, actually has to specify, I want to see the minutes of the commissioners' meetings from June through August. And so then you've got that in writing. So when he comes back later and says, well, I wanted all the commissioners' minutes from the time the county was organized. You didn't say that, and I would have denied that anyway, because that's not very particular. But anyway, so the other reason that I recommend that you have a requirement that it be in writing is that you get a little more time to respond if it's in writing, and we'll talk about that in a minute here. Okay, within a reasonable time, and that's not been decided in a court, and the public access counselor hasn't said reasonable means 2 days, 7 days, 5 days. The public agency is either to provide the requested copies or allow the person to make copies on either your equipment or their equipment, or you can deny it. You can charge a fee for copying, but that fee basically can't exceed 10 cents for an 8 by 10 or 8 by 11, 8.5 by 11, or 25 cents for an 8.5 by 14. There are some additional fees recorders get to charge. And there are some additional fees that county auditors get to charge for certain kinds of documents and for certifying documents and some things like that. You may require the requester to pay in advance. you know, if it's just one page, maybe it's not a big deal. But if you can just tell by the request that the volume of material is going to be a lot, you may want to say, we will determine what's disclosable, not disclosable, but before we actually provide you copies, we're going to expect payment. And right now we estimate that that's probably, what, 500, let's say 500 copies at 10 cents a page, so that's $50. Sometimes people may not really be interested in getting a copy if they can just, you know, have access to come look at the records. And then public agencies can charge a fee to certify that a public record is an accurate, true, and complete copy of the public record. And that's $5. Okay, you can't deny a request for a public record simply because the person won't tell you why they need it. You have to tell them why you're not going to give it to them, but they don't have to tell you why they need it, okay? Unless there's a statutory requirement for that, and there really aren't very many of those. Maybe the investigatory records of the law enforcement agency. You might have to say, oh, I'm a victim service provider, so. And then I'd ask for some identification, and then I might disclose to them. You can't interfere with the right to inspect and copy a public record. And you can't adopt a rule or procedure or impose any cost to limit access or to recover a fee for research. Now, there was legislation actually enacted this session that would have allowed you to charge a fee for researching to find a document if your research time exceeded 2 hours, but the governor vetoed that legislation because he didn't think that we ought to be charging people to research public records. That will probably be back on Organization Day or early in January for a potential override. Okay, denial of a public record occurs when the person makes the request in person or makes it by telephone. And the public access counselor has also extended this to say electronically, so I guess that's by email or text. And the person who's been designated by the public agency to be the person who makes public records decisions says, no, you can't inspect or copy, or 24 hours after anybody in the public agency says, nope, you can't have it. If the request is made orally, you can deny, by telephone or whatever, you can deny it orally. So I guess that means, according to the public access counselor, if you get an email requesting a record, you can deny it by email. Now, notice that's sort of a very collapsed time frame. If a person requests a copy by mail or facsimile, denial occurs within 7 days after they receive the request. Now, these time frames don't mean you actually have to produce the record. The public access counselor has said these are kind of the time frames in which you need to respond to the requester saying, we have your request, we're working on it, we will let you know within a reasonable amount of time whether we have any of these records and whether any of these records are disclosable or not. And again, if a request is made initially in writing, or if an oral request that's been denied is renewed in writing, you can deny the request if the denial is, again, made in writing, includes the statutory exemption that you're relying on, and includes the name of the person who's making the denial. And again, I think that's why having a form, and we've provided samples to all kinds of folks, that helps you identify who's making the request, the date they made the request, what they're seeking, and then you can either identify when you responded. Generally speaking, did you say, we'll get back to you, produce the record, deny the record, and then you've got a paper trail. Someone who's been denied access to a public record can file a lawsuit to require you to produce it, or at least to permit them to inspect and copy it. And the burden of proof is on you that the record is either a confidential or discretionary record. And the denial can't be just because they came in with blue hair that day. If there is litigation and the person requesting the record wins, they get attorney's fees automatically. If we win, it's up to the court to decide whether the public agency can recover attorney's fees. Then, in addition to requiring you to produce the document, if the court determines that the employee, the officer of the public agency kind of knowingly and intentionally denied access to a record they pretty much knew was a public record, they can be assessed a civil penalty that has to come out of your pocket. The first offense is $100, and subsequent offenses can be up to $500. So that's public records. Open door. Again, definitions are important. So a meeting is a gathering of a majority of the governing body of a public agency for purposes of taking official action. And an executive session is a meeting from which the public is excluded, except that the governing body can invite people necessary to carry out its purpose to the meeting. Things that are not meetings, social or chance gatherings not intended to work around the law. On-site inspections, like maybe you're going to take the commissioners and council out to look at a new courthouse somebody's built, or courthouse addition, to see, do they like that facility? Does that facility look like the kind of thing they want? That's not a meeting. Traveling to and attending today is not a meeting, even if all 3 commissioners from a specific county were here, or 2 were here, or a majority of the council. Attending meetings that are to educate you about your jobs as county officials is not a meeting. Let's see. That's pretty much it. I mean, there are a whole list of exceptions of things that aren't meetings, but generally speaking, those are the ones that are used to trip you up. A governing body is 2 or more individuals who are the board or commission, council, that are of a public agency that are authorized to take action on official business, official action, and any committee appointed directly by the governing body. Official action, this is another place where people get caught up, means to receive information. That's probably the most important thing you need to keep always in front of you if you're one of those folks that's going to be regularly in public meetings. Receiving information is official action, which should be taken in a public meeting. Other kinds of official action: deliberating, making recommendations, establishing policy, making decisions, and taking final action, and final action is voting. And the Indiana Court of Appeals distinguishes between making decisions and voting, and the only thing that has to take place, absolutely must take place in a public meeting, is final action. There are some provisions under which you could actually make a decision in what we'll call an executive session, which we'll talk about in a few minutes, but voting must always take place in a meeting open to the public. No ifs, ands, or buts. Public business is, again, this is a very broad definition, any function upon which the public agency is empowered or authorized to take official action. So levying taxes, assessing property. I need to move, don't I? There. See, I get talking and I forget to move that on. Okay. Then, just as with public records, there are with very, very few exceptions, meetings of governing bodies of public agencies must be open to the public so that they can observe and record them. And that and record is important. You can't throw the media out just because you don't think they ought to be recording it. Too bad. And then a secret ballot vote. You can't vote, you can't say, okay, we're not going to record the votes. Or everybody just, turn in your vote. Voting must be done in public also. You have to give notice of a public meeting. And this is a posted notice. This is not a notice that has to be published in a newspaper. You must post the date, the time, and the place for all meetings of a governing body at least 48 hours prior to the time of the meeting, not including Saturdays, Sundays, and legal holidays. And the notice of the meeting has to be posted at the principal office of the public agency, if there is such a place, and if not, you post it at the building where the public agency is going to have its meeting. So if the county council's meeting and the county council actually has an office in the courthouse or in the annex, you post it at their office. If they don't have an office of their own, and some don't, just post it, if they meet at the courthouse, at the courthouse. If they meet in the annex, at the annex. You must also give public notice to any media, or anybody actually, that's requested an annual written notice of their meetings before January 1st. So let's say by December 31st of this year, 3 newspapers in the county, even if there were 3 newspapers in the county, request all notices of all commissioner meetings. As long as they file that before December 31st or by December 31st, then you are required to provide them all notices of commissioner meetings. If they don't file it, you don't have to, but I don't fight with people who buy ink by the barrel. It's not a good thing. So provide it, and you have to provide it to them either by mailing it, or by sending it by email, or sending it by fax. And you can also walk it over, say the newspaper's office is across the street, or they have a little bureau in the basement of the courthouse. Maybe they do in larger counties. You can walk it over. They've got it. That's all that matters. The governing body can also adopt a policy to provide for additional notice by electronic means. And then you have to send an email notice to anybody who requested notice. And you have to post it on the government entity's website. Now, a lot of folks, the government entity, the county has a website, and they do a pretty good job of listing commissioners' meetings, council meetings, drainage board meetings, redevelopment commission meetings, and all of that. But that's not necessarily pursuant to a formal policy. It's just something they do. The danger here is that the statute says that if you adopt the policy, you have to send an email to everybody who's asked for notice. That could get a little bit cumbersome, I think. So we encourage counties not to adopt this policy. Okay, during the course of your meeting, you're supposed to keep a memoranda. It includes the date, the time, and the place, who's there, who's not there, the general substance of all the matters that were discussed or decided, and a record of all the votes that were taken. The memoranda, which are not necessarily minutes, but minutes can be memoranda, have to be available within a reasonable time after the meeting for the purposes of informing the public about what has gone on. So again, what is a reasonable period of time? If the meeting's in January and you don't have a memoranda available till November, that's probably not reasonable. If the meeting's in January and you're able to get it done by the first week of March, that's probably reasonable. It's what's reasonable under the circumstances. Let's just say it was a meeting that lasted 7 hours. You might probably have more time to provide the memoranda of that as opposed to a meeting that took 15 minutes. And then again, that's only if you're challenged. Minutes, if you have any, have to be available for public inspection and copying. Executive sessions. These are meetings from which the public can be excluded. Public notice is still required, that same 48 hours, not including Saturdays, Sundays, and legal holidays. That notice is still required, but in addition to the date, time, and place, you have to include in the notice a specific statutory exception under which the executive session is being held. Still have to have memoranda, but you also have to have certification in the memoranda that the only things you talked about in the executive session were things that for which you provided the statutory notice. So let's just say that you used the statutory exception for acquisition of real property up until the point at which an option is exercised. That better be the only thing you talk about. And if you end up talking about, let's say, whether or not you're going to fire the county highway superintendent, no. That shouldn't have been talked about in that meeting, and that makes your certification a little difficult to make. Final action, a vote, still has to be done in an open meeting. Now, according to the Court of Appeals, you could make a decision, but you can't actually vote on that till you go to an open meeting. And then you can't open a meeting, go to executive session, then go back to an open meeting. Statute says you can't do that. You can start with an executive session, or you could finish with an executive session, but you can't sort of put it in the middle, because that sort of implies that you're going to discuss things that you probably should be talking about in an open meeting. So there are lots of reasons for which an executive session can be held. And again, where authorized by state or federal statute that kind of mirrors the Public Records Act, for discussion of strategy related to litigation lawsuits that are either real and pending or have been threatened in writing, not just some rumor that, oh, I hear the county might be sued. Collective bargaining, discussion of strategy for collective bargaining. Discussion of strategy with respect to the purchase or lease of real property. To receive information about and interview prospective employees. To receive information about a current employee with regard to any possible disciplinary issues regarding their misconduct. When considering the appointment of a public official, and to discuss job performance evaluations, and to interview and conduct negotiations with industrial or commercial prospects. And just like the Public Records Act, any person can file a lawsuit to challenge a meeting that was not held in compliance with the open door law. There are some time frames and some restrictions on it, particularly if the county has issued bonds. And the court may tailor the remedy based upon the severity of the violation and based upon the harm that might occur if the decision that was made in a meeting is overturned. So in some cases, a court may say, go back and start at the beginning, and I want all your meetings to be in public. Or the court may say, you know, it really wasn't that big a deal. The public had notice, even though perhaps not adequate notice, but the harm of going back and starting over would be far more detrimental to the public than just allowing this to proceed. So that's kind of up to the court. And just like the Public Records Act, certain knowing and intentional actions taken by public officials or public employees to deny access to a meeting may result in civil penalties to that employee or public official. Then the Public Access Counselor. You all know who the Public Access Counselor is or what it is. You don't have to know who he is right now. This position was created by Governor O'Bannon back in a long time ago. I'll just say that, a long time ago. I can't remember. It's been so long. First by executive order, and then the General Assembly codified it, put it in statute. And the public access counselor's job function, among other things, is to establish a program to train public officials on the public records law and on the open door law, so that you are complying with the statutes, and so that you're not being harassed by citizens who feel like they're being excluded. There's the public access counselor is supposed to distribute publications that help you. And in fact, the public access counselor does have a publication. It's sort of a handbook to both the public records law and the open door law, and it's very helpful. Then the public access counselor also responds to either what are called informal inquiries or to formal complaints about alleged violations of either the open door law or the public records law. And there are scads of those on the public access counselor's website. And I will say they're not indexed, but you can look them up by subject matter, and they're very informative. And I will say that over the time that we're probably in like our 8th or 9th, maybe 10th public access counselor, the decisions have changed a little bit. Some of them are even more willing to find requirements for open meetings or open records than certain others. The current public access counselor views simultaneous communication of any kind, and that includes texts or email or IM instant messaging, potentially as a meeting. So for those of you who work with governing bodies, that's something you might want to be careful about. Now, it's not statutory, so what can he do other than shake his finger at you right now? But it would not surprise me at some point to see the public access counselor seek legislation to clarify that simultaneous communication is a meeting. So.